All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Mr. Gamper, you rightfully assume that you still have the floor.
I'm grateful. Yes, I know. Lost my earphones. Sorry, incompetently looking for my earphones. Your Honours will be aware that the defence also allege that Mr. Ongwen's fair trial rights have been violated even before he came into the physical custody of the ICC. And in particular, the defence complain about breaches of his right to counsel and of his right to remain silent in relation to a video interview that he gave to the press at the UPDF headquarters in the Central African Republic just after he had come into the custody of the Ugandan army. The defence argues that these alleged fair trial violations are part of a series of violations so grave that they warrant a stay of proceedings. Failing that, they seek the exclusion of an item, the video interview or an extract from it used by the prosecution, and further exclusion of the conclusions of one of the prosecution's mental health experts because she purportedly relied upon that video interview in coming to her conclusions. The first point I would make is this. The defence themselves acknowledge, to be fair, that it was on the very same day that Mr. Ongwen was handed over by national authorities to the court that the court's representatives introduced him to duty counsel. In other words, as soon as he was in the custody of the ICC, as soon as we had the power to act, we, I mean here, the court in general, not the prosecution, we provided him with legal assistance. So I would submit that even if procedural irregularities occurred before Mr. Ongwen came to the custody of the ICC, and even if those irregularities can be attributed to the ICC, Mr. Ongwen still had an obligation to mitigate any ensuing prejudice by pursuing a timely remedy. He didn't do so. The defence made no mention of this issue at any time till it appeared in the closing brief. It's true that they sought to oppose the prosecution's submission of the video evidence, but they did so on entirely separate grounds from those they now advance. But what demonstrates the lack, I hope it's not too much to say, of seriousness about these submissions made by the defence is that the defence themselves made use of video material from that same interview before Mr. Ongwen was provided with the assistance of counsel. The defence registered a portion of that interview in the evidential database. They made it available to the chamber and to the parties by disclosing it in the e-court disclosure system. They arranged for a translation of Mr. Ongwen's words in that video interview. And they played it in this courtroom. They showed it to the prosecution's very first witness, the anthropologist, Professor Allen. They asked him what he thought about it, and he answered. I won't summarize the answer here. And immediately following that testimony, through the procedure which the chamber has laid down, they submitted that interview, or a portion of it, in evidence so that the chamber could rely upon it in coming to their conclusions. If admission of Mr. Ongwen's video interview at the UPDF headquarters truly threatened the integrity of the proceedings. The defence would never have made use of any part of it. The submissions they make now are a late-coming procedural device in an attempt to derail the trial, apparently having forgotten, or perhaps hoping the Chamber and the other parties have forgotten, their previous reliance on some of the same material to which they now purport to object. Your Honours, finally, on the subject of fair trial, perhaps I, can invite the court to step back just a little. The prosecution says, it's disputed of course, but the prosecution says there is overwhelming evidence that Mr. Ongwen, both personally and through his involvement in crimes which were physically perpetrated by the fighters under his command, has committed the very crimes of the type that this court was set up to deal with. The lawyers defending him want to prevent the Chamber from coming to conclusions on that evidence. First and foremost, they're not asking for verdicts of not guilty. They're saying the trial should never have happened, and that even at this late stage, it should be stopped in its tracks. They're saying that the court cannot and should not do justice. If I can use the phrase, that's a massive ask. To quote Judge Fulford, in the first case that this court ever heard, a stay of proceedings is only appropriate where the trial process has, and I quote, been ruptured to such a degree that it is now impossible to piece together the constituent elements of a fair trial. This Chamber has been able to observe Mr. Ongwen throughout the proceedings. His lawyers have conducted vigorous cross-examination of the witnesses against him. They've made voluminous submissions on all of the legal issues arising. They've called over 60 witnesses to provide exculpatory testimony. If the defence are now to succeed in arguments that all of this has been for nothing, they must provide evidence, not mere assertions, that the trial process is broken beyond repair. No reasonable person with all the facts at their command could come to that conclusion. Your Honours, I want to turn now to a discussion slightly more technical and legal in its nature of what is said in the defence brief about the modes of liability whereby the prosecution invites the Chamber to find Mr. Ongwen guilty of the charged crimes. In its opening statement, and now throughout its closing brief, the defence has repeatedly returned to a single flawed proposition. Essentially, that Mr. Ongwen cannot be held individually responsible for his conduct because he was not the most senior leader in the LRA. Only Joseph Coyne, say the defence, could be liable for the LRA's crimes. And they argue that Mr. Ongwen therefore cannot be found guilty of the crimes with which he is charged by way of indirect co-perpetration, indirect perpetration, ordering, or command responsibility. If the defence's arguments are to be accepted, the court would be being put in a position that only the person at the very apex of a criminal organisation could be held responsible for crimes committed through that organisation. The prosecution submits that that is not the law. I take indirect co-perpetration first. It's charged, as I understand it, on the basis that a group of perpetrators sharing a common criminal plan have joint control over an organized power apparatus, and that apparatus is used to pursue a common plan. And the accused must have made an essential contribution to that common plan, which led to the commission of the crimes through its implementation. In this trial, that mode of liability applies to counts 1 to 23 and counts 61 to 70. The evidence at trial has demonstrated the existence of a series of common plans to commit the charged crimes through the LRA's organizational structure. And to make that case, we've led extensive evidence about the way in which Mr. Ongwen and his co-perpetrators, Joseph Coyne, Vincent Otti, amongst others, formed those common plans. There's evidence about how they communicated orders through the LRA's chain of command and how the orders were implemented by the rank and file. The defense is arguing, in essence, that an indirect co-perpetrator must exhibit a greater degree of control over the organization than Mr. Ongwen ever did. At paragraph 181, it is suggested by the defense that in order to be held liable, Mr. Ongwen must himself have been the person who issued orders. And 10 paragraphs later, 191, the defense argue that Mr. Ongwen's control over the LRA must have been, and I quote the adjectives they use, either great or absolute. This reveals, we submit, a fundamentally flawed understanding of indirect co-perpetration. And furthermore, it runs against the court's case law. There is no requirement for the prosecution to establish that Mr. Ongwen had absolute or great control over the LRA. It's enough to establish that the co-perpetrators jointly exercised control over the organization and that he was assigned an essential role in the implementation of the common plan, and that in turn resulted in the commission of the crimes. The defense's attempt to draw a distinction between a person's ability to cause an organization to commit crimes and his control over the organization demonstrates, we would say, that the defense is losing its grasp on what the real meaning of the word control is. The prosecution submit a person's ability to cause an organization to commit crimes is essentially the sort of evidence that will convince a chamber that he or she has joint control. What else does that word mean? Joint control over the organization and the crimes committed through it. I turn to indirect perpetration. And the defense makes similar submissions here. And this applies to counts 24 through to 49 in this case. We suggest that the defense is placing misguided emphasis on Mr. Ongwen's formal rank within the LRA. They suggest, it's at paragraph 201, that in order to be found responsible through this mode of liability, Mr. Ongwen must have been the, and I quote, highest authority in the organization. Well, that's wrong in law, we say. The Katanga trial judgment, which the defense cites at this paragraph as authority for its proposition, in fact runs directly contrary. The trial chamber in that case dismissed the suggestion that an accused person has to be the topmost authority within an organization to be held responsible for its crimes. As a matter of law, an accused person can be held liable under the theory of indirect perpetration for crimes committed by a discrete portion of the organisation that he controls, even if he doesn't control the entire organisation. And that, the prosecution would submit, exactly matches the facts as demonstrated by the evidence in this case. In any event, the court is, of course, looking to substance rather than formality. It's the conduct of an accused person, what he does, and the results of that conduct, rather than any formal position or rank, that determines the degree of control they exert over an organisational structure or part thereof. Turning to the mode of liability of ordering, which the defence attacks in a similar way. It's as an alternative to being found guilty as a participant, of course, that the prosecution suggests that Mr. Ongwen is guilty, or may be guilty, of some of the crimes alleged against him by means of ordering that they be carried out. The defence suggests that that is impossible because the prosecution are required to have demonstrated that a superior had a level of control akin to effective control, a familiar concept from command responsibility, over his subordinates. But again, submission has no legal basis. For a conviction by way of ordering, it's sufficient to show that the accused issuing an order was in a position of authority vis-à-vis the person who received the order. According to the case law, that doesn't require proof of control resembling effective control. It's sufficient if there's proof of some position of authority on the part of the accused that compels the perpetrator to commit a crime pursuant to the accused's order. It's perfectly sufficient that the people who actually carried out the crimes regarded as Mr. Ongwen as speaking with authority, that they perceived his words as orders to perform acts or omissions, that they felt obliged to comply. There's no need for any separate showing of effective control. And there is certainly no basis for the court to interpret effective control in the way that the defence urges in relation to command responsibility, the last mode which is attacked, to which I shall now turn. Let me make something which is no doubt abundantly clear to your honours, but may perhaps help those listening to follow. We are now in the realms of what the prosecution does not allege. We don't say that Mr. Ongwen is guilty because of his responsibilities via Article 28 of the statute. We say that he was at the heart of the commission of these crimes. He wasn't somebody who found out they'd been committed later and failed to take steps to discipline the perpetrators or to prevent it happening in the future. But nonetheless, by way of various alternatives, we arrive at the remote possibility, we would say, of guilt by way of command responsibility. It's a mode of liability that captures a superior's failure to exercise proper control over subordinates. And of course, it has to be proved that the superior's failure to act occurred when he had material ability to prevent or to repress the crimes. The defence suggests that in this case, only Joseph Coyne, and not Mr. Ongwen, could be held responsible by way of command responsibility. The defence suggests that Mr. Ongwen doesn't meet the threshold for having, that phrase again, effective control over the fighters who physically perpetrated the crimes. The prosecution emphasises that, once again, the court is looking here at the material ability to prevent or repress the commission of crimes, something going beyond mere influence, mere ability to exercise influence over perpetrators. Your Honours, the prosecution has introduced extensive evidence of Mr. Ongwen's effective control over his subordinates. I pick some examples. The Chamber heard from P0142, a witness who led the Lukodi attack under Mr. Ongwen's command. From P145, an officer from another brigade who also took part in that attack. From P0205, a senior officer in Sinia Brigade with detailed knowledge of 3 of the 4 attacks. You heard from a witness who told the court that he and Mr. Ongwen had been like brothers during their time in the Sinia Brigade together. And from another witness who was Mr. Ongwen's second in command of the Oka Battalion in the Sinia Brigade. You've heard from defence witnesses, D26, who had personal knowledge of Mr. Ongwen's organisational abilities as a brigade master. D27, who knew Mr. Ongwen when they were in the sickbay together. And D75, the officer in charge of support weapons while Mr. Ongwen commanded the Sinia Brigade. The sum of those witnesses' evidence made it crystal clear, we submit, that first in his battalion and later in his brigade, Mr. Ongwen was a vigorous, effective commander who insisted on strict adherence to the rules and whose word was law for those serving under him. He had the material ability to prevent or repress the commission of crimes by his subordinates. The defence suggestion that this testimony falls short of proving effective authority and control over his subordinates flies in the face of the evidence that I've summarised. And their suggestion that because the LRA was irregular in structure and that only Coyne was able to exercise effective control suffers from familiar defects. Once again, we see the defence attempting to tie Mr. Ongwen's liability to the structures of the LRA rather than the control he actually exercised as a matter of fact. Assessment of effective control turns on the reality of a relationship, not on the formal structures. And frankly, in any case, the suggestion that the LRA was non-hierarchical simply doesn't accord with the evidence that the Chamber has heard. The hundreds of questions which Defence Counsel have asked about LRA procedures in general over a period of 20 years or more provide, I accept, some support for the proposition that Joseph Coyne was a mercurial commander who might, at any time, on a whim, break the chain of command when he had the opportunity to do so, and order fighters many rungs down the chain of command below him to carry out or to refrain from certain conduct. But the evidence about the crimes that Mr. Ongwen is alleged to have committed contains no suggestion of any such interventions. To conclude on this subject, the suggestion underlying each of the defence's arguments about the charged modes of liability is that Mr. Ongwen was not the most senior figure in the LRA, true, and so cannot be responsible for the crimes committed by fighters under his command. Demonstrably false. That simply isn't the law. For each of the modes of liability charged, the court's focus will be on Mr. Ongwen's actual control over, and therefore culpability for, the charged offences. And regardless of Joseph Coyne and his role in issuing orders, the court can be satisfied, we submit, on the evidence we've heard, that Mr. Ongwen shared responsibility for planning criminal activities and used his position of control and authority to ensure that his subordinates implemented policies which resulted in the commission of crimes. If the defence's arguments were accepted, the court would be forced to conclude that only the most senior person in a criminal organisation could be held responsible for its crimes. It's flawed as a matter of law, and it's fundamentally at odds with the court's most basic imperatives. formal titles or ranks can't insulate an accused person from criminal liability when all the other indicators of responsibility are present. I want to turn to a new topic, if I may, and that is the reliability of the evidence concerning intercepted radio communications. So I'm moving away from the pastures of the law into the thickets of the evidence. There are going to be some visuals to accompany this. I hope that may liven up my presentation. Can I just check that, as they say, we have the floor? Yes? Grateful. The defence suggests to the Chamber that for the most part...
No, I would have said you have the monitor, but okay.
Yes, I think that's probably correct, in fact. I'm grateful. The defence is saying that we don't have any idea who's talking on most of the 600 sound recordings which are in evidence. We don't have any idea what they're talking about. Most of the material hasn't been transcribed or translated, and they complain that we have cherry-picked, to use the slang, picked the best bits, and they ask the Chamber to disqualify this whole approach. It's just worth summarising the scale of this evidence. There are approximately 22,000 pages of logbooks. I had in mind that I might, at this stage, get the trial support assistant dramatically to wheel all the logbooks in on a trolley, but I recognise that I'm not in a theatre, so I must restrain myself. 22,000 pages, about 700 pages of shorthand rough notes, the working materials as the interceptors were listening to the LRA radio and scribbling down on their pieces of paper. There are about 300 Ugandan Army UPDF intelligence reports based on the logbooks, and there are about 600 cassette tapes containing sound recordings of LRA radio transmissions. That's in evidence, and it's been in evidence since the beginning of the trial. The prosecution's purpose in adopting this comprehensive approach was to ensure that as the evidence developed over what's turned out to be 3 years of litigation, material which could be of relevance to both parties, the participants, the Chamber itself, would be available as and when issues arose. And the extensive use which both parties have made of reference to logbook entries concerning issues of high relevance. Mr. Ongwen's injury, his time in sick bay in late 2002 is an example which springs to mind, demonstrates that that was, on the prosecution's part, entirely the right decision. The defence themselves have made significant use of the intercept material in their submissions, for example, about the Pajule attack and about the duress to which Mr. Ongwen is alleged to have been subjected, the very same material to which they are objecting. The prosecution would observe that they can't reasonably have it both ways. But of course, the large majority of the material has remained unused. The defence's position appears to be that it's unfair for the prosecution to have looked for and to have found a few needles in the haystack unless the prosecution can demonstrate that they have described and analysed every blade of grass in that haystack. And failing to do that, say the defence, the prosecution should be debarred from using the relevant material. The prosecution would say there is no principle of law or of common sense which suggests that the Chamber should do as the defence ask. In fact, say the prosecution, we've gone to pains to help the defence and the other participants by creating two documents which provide a key to the intercept material. And an example of the first of those is on the screen in front of me, but not, I think, available to the public, which is slightly disappointing.
I think we can fix that soon. And by the way, it's not only not available for the public, also not available at the moment, at least, I think, here in the courtroom too.
Hmm.
Yeah.
Evidence 2?
Oh, no, now I have it, yeah. Yeah.
Yeah, I'm good. Yes. Sorry for the delay. The first of the two documents which the prosecution has created is the Intercept logbooks timeline. This is an example of just one page relating to one source. Your honours will remember there are logbooks from 3 separate sources: the Internal Security Organisation, the Army, and the police, very often recording interception of radio transmissions on the same day, about the same events, with, on the face of it, the same people talking. The timeline helps to identify how many and which written records cover a particular date, so that if we just concentrate on the top line, we can see that in relation to one particular date, there are, and this is just the Internal Security Organisation, leave aside what there is from the Army and the police, there are 4 separate sources relating to the one event on the particular day. For the most part, it's 3 separate sources. So we've provided similar documents for all of those 3 sources. Some considerable assistance, I would submit, provided at an early stage. But there's a second navigational aid as well. We called it, perhaps rather grandly, the Intercepts Master Table. But it is quite masterful, I respectfully submit. It links the sound recordings, those 600-odd cassettes, which you see in the left-hand, second to left-hand column, and the date in the extreme left-hand column. And then as one progresses across from left to right, it helps the reader by telling them in which document and at which page the interception on a cassette tape is dealt with in parallel form in the various logbooks. And again, we are dealing here at first with the ISO, then with the UPDF, and then with the police. It isn't always the case that there is an entry in every record made by every organisation. But just take the second row down. We see the sound recording. We see that there's a corresponding page, this is the 7th column, in the ISO logbook, a corresponding page in the UPDF logbook, a corresponding page in the ISO shorthand rough notes. Then there were copies made for the purposes, this is back in 2002, I think I'm right in saying, in the days of faxed transmissions. Copies were made, handwritten copies were made, so that it could be faxed through to the people in Kampala. And then in the right-hand columns, one learns where the sources of the sound recording are, what the serial number was, and whether there are any notes written in respect of the sound recording. These documents were provided to the defence long before the trial began, within a short time of the prosecution creating them. And in addition to that, the prosecution carried out extensive analysis of the intercept evidence. Logbooks were analysed page by page, audio recordings summarised by language staff, and compared, where relevant, to the logbooks to assess whether the audio was of sufficient quality and relevance for transcription and translation. And where it was, we did just that, and we disclosed those translations to the defence. Where there was no formal translation, the prosecution provided the summary, known as a scan, to the defence. If we weren't in the dog-eat-dog world of the courtroom, I might confess myself a little bit hurt by the inaccurate and unfair criticism which is contained within the defence's brief on this score. The reality is, the prosecution took extensive, I was going to say unprecedented, but that's rather too bold a claim, in any event, perfectly satisfactory steps to analyse this intercept evidence and to share the results and the tools for further analysis with the defence. Defence's next criticism is, and I think we can take the table down from the screen, distracts perhaps. Defence complain about the bias of prosecution witnesses P003 and P0059. Well, the Chamber will make its own assessment of the motives and the reliability of those witnesses. I'm not going to talk them up or down now. It's an entirely fair observation that they are, and they were at the relevant time, members of the Ugandan government's military and security forces. They regarded Mr. Ongwen and the whole of the LRA as their enemy. We accept that. The defence suggests that even at the time these records were created, the Ugandan authorities are seeking to cast their opponents in the worst possible light. They use those words at paragraph 248. And that because the records were created as part of an intelligence gathering operation, in the midst of a civil war, they lack what they call forensic fair trial safeguards. The prosecution has observed in the past, and I touch on it again, exactly the opposite. The people making these records were fighting a war. People's lives were on the line. The idea that instead of recording the actual information which was being transmitted, they would go to the trouble of creating false records in the hope that years later they might pervert the course of justice and bring an innocent man down is faintly ludicrous. And the sheer scale of the material, the very large number of witnesses who testify to its creation, make this an unrealistic suggestion. Effectively, the defence is suggesting that some malevolent criminal mastermind in the Ugandan government decided, while the LRA was still a genuine threat to civil stability in the nation, that they would create a vast reservoir of false material on the off chance that one day, in the uncertain future, they might be able to incriminate one of or more of the LRA commanders who might survive to be arrested in years to come. The next criticism is perhaps more technical. The defence observed that the sound recordings have not been authenticated. They suggest that they could have been tampered with, or perhaps, in a less malign way, altered by the enhancement process. And they complain that they haven't been subjected to expert analysis. In particular, they complain that the sound recordings haven't been compared with Mr. Ongwen's voice using specialist software which is available. They assert that the chain of custody is murky and the documents haven't been certified by the relevant authorities. They observe that many of the tapes show indicia of being copies rather than the originals. Well, Your Honours, of course it is true there has been no digital comparison carried out in this case by either side. No doubt the defence, like the prosecution, learnt that the poor quality of the sound recordings meant that that would not be a practical proposition in creating evidence which would approach the necessary degree of certainty. But the suggestion that absent such comparison, the identification of Mr. Ongwen's voice on the sound recordings can't be made by any other means is without a foundation in law or fact. The Chamber will be aware that the prosecution relies on the evidence of 18 individuals involved at various levels of the 3 different organizations, the security organization, the army, the police, which were conducting simultaneous and often complementary interception of LRA radio transmissions. And each of those witnesses provides similar detailed evidence of their organization's interception operation. They give corroborative accounts of how their operation started. They name the same colleagues. They describe the same interception process. They confirm what records were produced. They identify samples of the material, the logbooks and the cassette tapes. Your Honours have seen witnesses have those items in their hands and say, yes, I was making this. And those items have been submitted in evidence. When examples of key communications, key radio transmissions were played to former LRA fighters, P16, P440, and to the people on the other side, P59, P3, they all, irrespective of which side they'd been fighting on, confirmed that those were sound recordings of LRA radio communications, and they recognized the voices of the speakers and the content of the communications. Prosecution witnesses were not alone in that. Defense witness D100 did likewise. And as for tampering, the prosecution could have called 100 witnesses rather than a mere 18 to say they hadn't tampered with the evidence before it was handed to the prosecution. We still would not have succeeded in disproving the negative in that respect. But again, the tampering would, for much of the material, have had to take place back in 2004, or even earlier, before it was collected by the prosecution. At a time long before Mr. Ongwen's arrest warrant itself was issued and became public. And the tampering would have had to be on a gargantuan scale, given the volume of the material. What about enhancement? Is it possible that by some process that is, I submit, frankly, fanciful, that in making the voices to be heard on the sound recordings louder and in reducing the background crackle and pop, the prosecution has accidentally, perhaps the defence is saying on purpose, managed to make the voices of speakers who weren't Mr. Ongwen resemble his voice to the extent that it deceived people who knew his voice well. But in fact, witnesses were played at different times, both enhanced and unenhanced versions of the same material. Very often it is the case that when the prosecution first investigated the matter and spoke to a witness, there had been no enhancement. They listened to what you might call the raw material. And then subsequently, by way of confirmation and in the courtroom, the witness listened to an enhanced version with exactly the same results in terms of identifying the voices of speakers, including Mr. Ongwen. What about expert analysis? Well, prosecution did call an expert, Mr. French. It's fair to say that he examined only a fraction of the total number of sound recordings. It would have been prohibitively expensive for him to conduct an expert analysis of them all. The defence themselves notified the chamber that they would be calling an expert in this field, and nothing prevented them from doing so. If he had concluded that there was evidence of tampering, no doubt they would have done so, but they chose not to. In any event, Your Honours, all of this is speculation. The chamber is asking the chamber to concentrate on what evidence there might have been. That's fruitless. The question of the tape's authenticity has to be determined on the basis of the evidence that there is, not on the basis of speculation about possibilities of other evidence. And we say that the evidence there is compelling. And if I may, I'd like to take Your Honour in a visual sequence through just a couple of examples. They'll come up on the screen. Prosecution alleged that Mr. Ongwen, after attacking Lukodi, reported that attack back to his superiors. Let's consider the consistent evidence from diverse sources on exactly that point. The court has heard the audio recording of Mr. Ongwen reporting the attack. It was recorded back in May 2004. The court has heard the testimony of former LRA signaller P16, identifying the voice of Mr. Ongwen in that audio recording reporting the attack. The testimony of ISO officer P59, again identifying the voice of Mr. Ongwen reporting the attack, has been heard by the chamber. The testimony of UPDF officer P3, also identifying the voice of Mr. Ongwen in that same transmission reporting the attack, has been heard. The court has seen the contemporaneous records of intercepted communications in the logbooks by the ISO in May of 2004. Mr. Ongwen recorded as reporting the Lukodi attack on the radio. That means that the persons making these records recognized his voice not now, in 2018, not at the time they first made their statements, perhaps in 2007, but at the time when it was transmitted in 2004. They'd been listening to him and other LRA commanders speaking over the radio for months and years. They knew the voices of those commanders. They knew Mr. Ongwen's voice. And the same goes for the report in the logbooks of the UPDF, the army. Quite separately, Mr. Ongwen's voice intercepted, recognized, and his words summarized by the Ugandan military. And finally, you've heard from Mr. Ongwen's subordinate officers, P205, and the other officer who was his deputy in the Uka battalion. They were present when Mr. Ongwen made his report over the radio. And that report was actually heard at the time by LRA radio operator, many miles distant, P16. So 3 people actually heard it at the time on the LRA side. These different items of evidence from diverse sources, produced and obtained at different times, are all consistent on the fact that it was Mr. Ongwen who reported attacking the camp at Lukodi. The only reasonable conclusion we suggest is that the evidence taken as a whole is reliable and credible. I'm going to take a second example. I'll try not to labour the point for too long. The prosecution alleges that Mr. Ongwen attacked a camp known as Labwar Omor or Palaro. This is not a charged attack. They allege that he attacked it on the 23rd of November 2003. Again, let's consider the evidence from diverse sources. There's the audio recording of senior LRA commanders discussing how Mr. Ongwen had attacked Laboromore. You heard the testimony of P59, the ISO officer. He, too, said that the tape was a discussion between LRA commanders of Mr. Ongwen's attack. You heard the testimony of former signaller, LRA signaller, so on the other side of the conflict, P16. He listened to the tape. Yes, he said, senior LRA commanders talking about Mr. Ongwen's attack. You've seen the contemporaneous records in the ISO logbook. You've seen the records in the UPDF logbook. And you've heard from former LRA fighter 309, who testified that he and his fellow fighters attacked Laboromore under the command of Mr. Ongwen. Likewise, witness 372, who attacked at that place under Mr. Ongwen's command. Once again, the pattern is the same. Different items of evidence, diverse sources, produced at different times, but they are all consistent about the fact that it was Mr. Ongwen who attacked this camp. Again, the reasonable conclusion, the only reasonable conclusion we submit, is that this evidence is reliable and credible. And the pattern's repeated time and again, even when the source of corroboration is evidence put before the chamber by the defence. I mentioned their witness D100. He's an LRA signaller. Perhaps I can refer back to what Mrs. Adeboyejo said. In the end, it perhaps doesn't matter very much who's calling a witness. The importance is the potential truth of what they have to say. Well, what did Defence Witness 100 had to say? He listened to Mr. Ongwen's voice in audio recordings of Intercepts, making reports relating to the Odek attack. Your Honours may recall the conversation about a diamond. And in doing so, he corroborated the testimony of other LRA, ISO, UPDF witnesses who identified Mr. Ongwen and corroborated the contents of contemporaneous records. The intercepted communications are even corroborated by Mr. Ongwen himself. When he was speaking to the defence medical experts, he acknowledged to them that he had led an attack at a location known as Koch Ongako. And in doing so, Mr. Ongwen himself corroborated the testimony of other LRA and ISO witnesses who identified his voice reporting the attack on an audio recording of intercepted radio communications. And he corroborated the contents of those communications as well. Whichever way you look at it, the prosecution says, the only reasonable conclusion in this case is that the evidence of the intercepted communications, whether it be sound recordings or logbook records or the recollection of the individual witnesses who have testified, taken as a whole, is reliable, credible, and compelling. I have two more sections in the remarks that I'm going to make. They concern mental health, what broadly I will put under the heading of Article 31(1)(a) of the Rome Statute, and duress, Article 31(1)(d). But I also want to address Your Honours about how they do or don't overlap, because there are potentially significant submissions made by the defence in that regard. And I shall start, if I may, with mental health, 31(1)(a). The defence experts assert that at the time of every single crime, apart from the crimes of a sexual and gender-based nature, as Mrs. Adeboyejo reminded Your Honours this morning, that at the time of all the other crimes, Mr. Ongwen's capacity to understand the nature of his conduct or to control his conduct had been destroyed by mental illness. I pause for a moment to consider the defence's understanding of the word destroyed. To most people's ears, I'm prepared to venture, to my ears in any event, I suggest the word has an air of totality and permanence about it. Something akin to Judge Fulford's description of a thing so badly damaged that it's impossible to piece it together. That's what destruction sounds like to me. We don't expect something which has been destroyed to be up and functioning a short while later. We know a great deal from Mr. Ongwen's account of his thought processes while he was with the LRA, through the various remarks that he has made to those medical experts whom he permitted to examine him. We know that his capacities to understand and to control his conduct were not destroyed. He told the defense experts when they first examined him in 2016, it's at page 10 of their report, that one of the things he liked least in the bush was the atrocities. He told the defense experts that he had refused a direct order from Joseph Coyne to kill religious leaders and elders during the peace negotiations. He told them, this is at page 15, that while in the LRA, he didn't like the things that he saw or did. Perhaps most startlingly of all, given the propositions made by the defence on this subject, he told the defence experts that following his attainment of the highest possible rank in the LRA, he began openly to question the moral basis of the LRA's war. In the light of those remarks, it's perhaps unsurprising that when the court-appointed expert, Professor de Jong, examined Mr. Ongwen later in 2016, he concluded was that Mr. Ongwen had, and I quote exactly, a functional conscience despite the cruelties he committed. And all of this is simply based on what Mr. Ongwen himself says. I shan't begin to rehearse the copious evidence of the non-destruction of his mental capacities from people who actually knew him at the time of the charged crimes. People who consistently speak of his kindness, his clarity of thought, and his capable leadership. Your Honours, I respectfully suggest that the proposition that at the time Mr. Ongwen was in the LRA and at the time of the crimes which he is accused of, his capacity to understand his conduct and its potential unlawfulness, his capacity to control that conduct is simply flatly contradicted out of his own mouth, out of the observations of the defence experts themselves, and out of the mouths of the copious witnesses who have testified about his behaviour and their knowledge of his character at the relevant time. I want to turn now to the relationship between the mental health issue under Article 31(1)(a) and the duress issue under Article 31(1)(d). The defence argue that it is only their experts who have taken the necessary holistic approach in diagnosing Mr. Ongwen's mental disease, and that they are right, as a result of this holistic approach, to come to the conclusion that LRA coercion left him with no free will and that every action was under duress. I'm summarising paragraph 529 of the brief, and it segues from beginning on mental health to ending up in the territory of duress. The prosecution's submission is that this cannot be. Mental illness sufficient to satisfy Article 31(1)(a and duress, we suggest, cannot coexist. Duress requires that the accused, when carrying out the conduct which is alleged to constitute a crime, acts reasonably and does not intend to cause a greater harm than the one he's seeking to avoid. But a person whose ability to understand what he's doing has been destroyed won't be able to act reasonably and is incapable of carrying out that balancing act of harms which is required of duress. And oddly, a little later in their brief, the defence themselves appear to acknowledge this point. I'm looking at paragraph 602. They assert, and I quote, Mr. Ongwen's mental disease, with his arrested, childlike mental state, destroyed his capacity to act reasonably and necessarily. Well, those are the requirements of duress. They can't both say that his capacity to exercise those characteristics of reasonableness and necessary action have been destroyed and also rely upon the Article 31(1)(d) route for excluding criminal responsibility, which requires him to be exercising those characteristics. It's one thing or the other. We would suggest that it's only if the Chamber is satisfied that the Article 31(1)(a) incapacity doesn't apply that realistically the matter of duress can begin to be considered. And of course, we would say, at that point, the expert medical opinions of the defence doctors, although they talk a lot about duress, ceases to be of any relevance. They're medical experts. They're not experts in reasonableness. I don't believe such a thing exists. They're not experts in duress or in its other key ingredient, necessity. Those are matters which the trial chamber will assess without the need or, frankly, the possibility of any expert intervention because they are everyday concepts and everyday matters. The defence repeatedly make reference, I quoted them just a moment ago, to Mr. Ongwen's childlike nature. And this feeds into a narrative which, as I understand it, runs parallel to the statutory grounds for excluding criminal responsibility on which they rely, mental illness and duress. Running through their conduct of the trial, running through their brief, is the notion, not always clearly expressed, that Mr. Ongwen's age cannot be calculated by the mundane process of the elapse of years. That by some more psychological or spiritual calculus, he is in fact still younger than 18. And thus, in the spirit of the law, if not in its letter, he is a person who should not properly be prosecuted. And in part to bolster this notion, they called witness D113, who told the chamber that a child abductee's mind is not his or her own. I'd invite your honours to consider that hundreds, probably thousands, of child abductees retained sufficient control of their minds to be able to plan and to carry out their own escape. The chamber has heard from dozens of such individuals. They'd undergone the same experience of abduction and initiation that Mr. Ongwen underwent. Many, perhaps all of them, remain affected by those experiences. But are they all to be treated as trapped in a childlike mentality which prevents the authorities from holding them to account for their actions later in life? In any event, the prosecution suggests, in the case of Dominic Ongwen, the Chamber can decide for itself whether he does indeed have a childlike mind by reading the transcripts of his telephone calls with the witness D13 in 2015. I'm not going to quote from those documents. Your Honours have them in evidence. But I hope I can fairly summarise them by saying that he spoke at length. He's charming, amusing, quick-witted, something of a schemer, rapidly makes calculations between different currencies. He boasts about how he can speak multiple languages, how he's enjoying learning more. He plots with the witness as to how he is going to get visits from all his wives and children, wives is his word, while he's in the detention centre. He laughs with her about how his advice to Mr. Coyne concerning LRA operations was always right, and how Coyne began to believe that Mr. Ongwen had psychic powers. He tells her that he's the cleverest man in Acholi. Your Honours, that conversation gives the lie to the notion that Mr. Ongwen has a childlike mind. I want to turn now to the claim that the defence makes, contrary to the proposition put to the defence experts by me when I was questioning them, that in fact they did properly consider collateral sources of information, that they undertook the process which was referred to as triangulation, that is to say, seeking to find different sources or means by which they might come to a firm and reliable conclusion. Let's be fair. Back in 2016, before the trial began, the defence experts did indeed speak to 4 people who knew Dominic Ongwen at the time when these crimes were committed. And of course, thereby they acknowledged the importance of this kind of information when coming to conclusions about his mental health at that time. None of those 4 persons, and Your Honours have the summary provided by the defence of what they said to the experts, none of them said anything suggestive of mental illness. But thereafter, from that time onwards, once the trial started, the defence experts seem to have gone to pains not to make themselves aware of any of the voluminous testimony about Mr. Ongwen's behaviour given in the courtroom. They remained unaware of it, it seems, until they were confronted with it in cross-examination. They willfully or negligently cut themselves off from a vital source of evidence which could and should have guided them in their assessment of the accuracy of Mr. Ongwen's accounts to them, and ultimately should have informed their diagnosis. Let's just look briefly at the other collateral sources to which the defence refers in defending their experts in their closing brief. They remind the Chamber that D7, this is at paragraphs 619 and 620, D7, who was with Mr. Ongwen when they were abducted in 1987 and spent the early months of their abduction together until they were split, spoke about the atrocious events they witnessed together. He never saw Mr. Ongwen again until he testified at this trial. D7 told the court he was very scared by what he witnessed, and he thought that Mr. Ongwen was really depressed by what he'd seen. That was nearly 20 years before the charged period. But that's it. That's the totality of what the evidence has got to say. Sorry, what the defence have got to say about the evidence from people who observed Mr. Ongwen in the bush at the time of these crimes. People who have testified in this trial about it on oath. The defence make no attempt whatsoever to engage with the evidence from Mr. Ongwen's subordinate officers, his child escorts, the women whom he regarded as his wives, about their testimony concerning his ability to make fine judgments, to empathise, to push back against impractical orders, to argue with Coyne about morality, and his attempts to escape. All of this ignored. It's simply too inconvenient for the defence narrative. What they do attempt to do, lumping all of this evidence together, is to suggest that the prosecution experts have ignored the possibility that what the witnesses with Mr. Ongwen in the bush saw were his good days. That's paragraph 624. And that there must have been other bad days about which the chamber hasn't heard. But this is a false characterization of the evidence. What the prosecution experts pointed out is that all the accounts they were presented with seemed to represent good days. They were open to cross-examination by the defence about contemporary evidence from LRA insiders about the bad days. But no questioning took place because there is no such evidence. So, how did the defence tiptoe around this inconvenient truth? Well, they rely upon Professor Avuga's evidence when he says that in our part of the world, psychological distress is sometimes somatized into physical symptoms, and at other times, psychological distress is interpreted as spiritual possession. And undoubtedly, Professor Avuga is an expert in a position to make such an observation with authority. Let's assume that's correct. What is the evidence that Mr. Ongwen was somatizing, was demonstrating physical symptoms which were an expression of his psychiatric illness? There isn't any. None of the witnesses who knew him well speak of his illness in that way. Sure, he gets wounded in combat, but that's not what the professor was talking about. None of the witnesses who knew him well believed that he was possessed by spirits. In fact, they all said what a normal, nice chap and effective commander he was. And in the alternative, the defence say, well, the prosecution haven't proved beyond reasonable doubt the defence evidence that mental illness can exist in a person who may sometimes exhibit signs of happiness or sociability. That's a quotation from defence paragraph 636. And that statement, I suggest, encapsulates the defence approach to the position regarding the application of Article 31(1)(a). It makes a claim in the broadest general terms without relating it in any way to Mr. Ongwen's case or the specific crimes that he is alleged to have committed. It misstates the prosecution case. The prosecution isn't arguing that mentally ill people never show signs of happiness or sociability. What we do point to is the fact that none of the people around Mr. Ongwen at the relevant time speak of him being anything other than happy and sociable. And it fails to take into account the question of capacity, the key question of capacity. Mentally ill or not, and of course the people around him weren't in a position to make a diagnosis, a point well made by the defence experts and which I accept. The question for the Chamber is, even if there is such illness, were his mental capacities destroyed as a result thereof? If he'd been incapable of understanding what he was doing or of controlling his behaviour, the people around him would have noticed. That's precisely the kind of lack of capacity which leads people to become concerned about people with severe mental illness, because they begin acting erratically and dangerously to other people and to themselves, because they can't control themselves, because they don't understand the world around them. And of course, that is exactly the opposite of the observations made by the people who knew Mr. Ongwen with the LRA. Finally, Your Honour, on this point, and it may be that I can leave the topic of duress to deal with immediately after the lunch break, and then hand over seat to Mr. Black. Finally, I draw Your Honour's attention to paragraph 637 of the closing brief. The defence accept there, indeed they positively assert in that paragraph, that functionality, person's ability to conduct their social and professional relationships satisfactorily and to get on with their work, they accept that it is not incompatible with mental illness. Accepting the defence claim at face value, it is fatal for their case. In other words, they're saying, and the prosecution agrees, that the key question isn't, was Mr. Ongwen mentally ill, on which Your Honours have heard diverse, indeed conflicting evidence, but what effect did any such illness have on his mental capacities at the time of the charged crimes? The defence experts never even tried to find out in relation to specific crimes or perhaps specific attacks at which crimes were committed, what Mr. Ongwen's state of mind was. It appears they did not even ask him those kind of probing questions. The evidence from the witnesses who were with him at the relevant times chimes in with the conclusion of the prosecution experts. There is every reason to conclude that he was in full possession of the capacities which the Chamber has to consider when those crimes were committed. I thank you for your attention. It's a little early, but I think it's probably sensible to leave duress, which may last some 20 minutes or so, until after lunch.
That sounds reasonable. We will have now the lunch break until 2:30.
All rise. Veuillez vous lever.